Welcome back to Left, Right and Centre. Does the government in power have the right to amend any part of the Constitution that it wishes? Is the ruling on maintaining the basic structure of the Constitution sacrosanct? We ask this because in the debate in Parliament on the Delhi Services Bill, an argument, a strong one, was raised by the former Chief Justice and now MP Ranjan Gogoi that the legal interpretation of the landmark Keshav Nanda Bharti case should still be open. The opposition worries that if the basic structure of the Constitution is changed through an amendment in Parliament, we could potentially cease to be the democracy that we are. So that's their concern. There are others who say that constitutional amendments just cannot be restricted in their scope. So that's what we are looking at. Joining us now to debate this, first up, we are joined by Professor Faizan Mustafa, who is a constitutional expert. Later on, we'll be joined by Sanjay Hegde and Deshrata Nigam. Professor Faizan Mustafa, I thought since a lot of people would not necessarily know of the case that we are talking about over here, that we should actually have some basic questions. So let me ask you this. Is there an inherent limitation in Parliament's power to amend any part of the Constitution?
You see, this whole question of basic features of the Constitution was first raised by Justice Mudolkar and Justice Hidayatullah in 1964 judgment of Sajjan Singh. So it is before Keshavananda Bharati in 1973. They expressed the doubt. For instance, they said that people who take oath by becoming member of the Parliament, that they would uphold this Constitution and law. Can they destroy this Constitution?
Okay.
And the question put by the judges was very clear, that we are a sovereign democratic republic. Does that give power to the Parliament to change the democratic character of the Constitution? And they also quoted a 1963 judgment of Pakistan Supreme Court, Chief Justice Cornelius, who has similarly said that there are inherent limitations.
And where the words basic structure was first used, which is bizarre. It was actually a Pakistani judgment.
That is not 73, it is 1964.
Yes. But it was the 73 judgment which used the words in Keshavananda Bharti
but I'm talking of even prior to that. Even prior to that, Supreme Court had expressed the doubts that Parliament has unlimited power to destroy the Constitution.
Okay, next question.
That was the position of that Congress government. Just 1 minute.
Go ahead.
Now, in Keshavananda Bharati, of course, the bench was divided 7-6. It can be debated. One can also say that the whole judicial review idea is anti-democratic. Once there is a law passed by the Parliament, how can unelected judges nullify that law?
Sure.
But look, even the constitutional justification within the Constitution, within Article 368, which talks of amending power of the Parliament, it says once an amendment has been passed, the President shall sign it. So President does not have the power to reject a constitutional amendment. He has this reconsideration power. He has to straight away sign it. And then it uses very crucial words in Article 368, Clause 2, that thereafter the Constitution shall stand amended.
Okay.
Now, this expression that the Constitution shall stand amended, Supreme Court said in Keshavananda Bharati, means that there must remain some part of the Constitution which will stand amended. And that is the part to which the court called the basic structure of the Constitution.
Second question, did the Constituent Assembly make a distinction between essential and non-essential features of the Constitution? In other words, the basic structure, some would argue, is a part of the Constitution which has been deemed to be essential and cannot be violated. However, my question is, that is what the Keshavananda Bharti judgment, which was a 7-6 verdict, arrived at. If you go back, what did the Constituent Assembly say? Did they make a distinction between essential and non-essential?
No. It did not make very clearly, but then Constituent Assembly did not talk of collegium either. It did not talk of right to privacy either. Now the doctrine is that there are silences of the Constitution which are as important as what the Constitution expressly declares. But if you look at this expression that the thereafter the Constitution shall stand amended is not a silence. It's a very clear expression that the entire Constitution cannot be destroyed. There must remain at all points of time some part of the original Constitution which will stand amended. This expression gives legitimacy to the whole doctrine of basic structure.
Next question. Did the Constituent Assembly expect quote-unquote basic structure to be deduced from the preamble?
Not necessarily, but even in this case, Sajjan Singh, which I am saying that is prior to Keshavanand Bharati, where Supreme Court is raising a question, that they are not pronouncing anything, they are raising a question that it would be surprising if Parliament can destroy the Constitution, if people who take oath to uphold the Constitution can say that we are replacing this Constitution with another Constitution. There they very clearly say in one of the paragraphs that probably the preamble incorporates the basic features. They use word basic features.
Okay. To those who say that the Parliament should be challenged in all facets through an amendment, should that be required, that the Constitution can be challenged through an amendment in Parliament and any facet of it, they ask, does basic structure uphold the supremacy of the judiciary more than that of the Constitution? And they say so by arguing that there are so many judgments which keep saying that basic structure, this is something which works for the judiciary, it doesn't work for the Constitution. There's an ethical issue here.
There is some substance in this argument. You see, we have one Article 13 in the Constitution which says that no law shall be passed which contravenes fundamental rights. The expression judicial review has not been used in the Constitution. But Chief Justice Patanjali Shastri has said that Article 13 is there in the Constitution out of abundant caution.
Yes.
Even if it is not there, and if there is a law which contravenes Constitution, somebody has to strike it down. And it cannot be Parliament. It cannot be the executive which commands majority in the Parliament. So the only organ left to look that Parliament has not turned majoritarian would be an independent judiciary.
Was basic structure violated when socialist, the words socialist and secular were added to the preamble?
Not really. If you look that there have been petitions which have gone to the Supreme Court saying that word secular and socialist be deleted. And the position which Supreme Court has taken that since preamble has been held to be the basic structure, we can add something to basic structure, but we cannot delete anything from the basic structure. Moreover, this word socialist, to which you are specifically making a reference, if you look at the preamble, if you look at Article 39B and C, which very clearly say that there shall not be a concentration of wealth and that the national resources should be so distributed to subserve the common good. So there are already express provisions in the constitutions which are tilting in favor of socialism. So what was already expressed in the Constitution, but word was not used, that word was used by the 42nd Amendment in 1976.
Fantastic conversation, Professor Mustafa. Thanks very much indeed.
Thank you.
I've spent the last 3 days reading the judgment and a lot of the dissenting judgments as well. It's absolutely fascinating. Desh Ratan Nigam and Sanjay Hegde joins us. Desh Ratan Nigam, should Keshavananda Bharati be re-argued?
Well, in fact, if you look at the ratio, it is 7:6.
Yes.
Very narrow.
Yes.
And 6 people didn't want. So it's high time that we start, revisiting that. And it's a very debatable. Somebody who's read Mr. Adhyar Junia's book, which Mr. Ranjan Gogoi also specifically mentioned in Rajya Sabha, would give a lot of insight into this subject. Now, let me tell you how the Supreme Court is encroaching upon legislative functions. Collegium, we know, was not there in the Constitution. The absolute power was with the president, and they brought this concept of collegium, where the original concept was the president will appoint after consultation with Chief Justice of India. This is how they have taken over the executive functions of the president, which the Constitution did not allow. Now, second, the appointment of Chief Election Commissioner. It is no responsibility under the Constitution of the Supreme Court Chief Justice to be a part of the appointing process. That's in executive. They could at best, set aside the appointment and ask government to make a fresh appointment. They cannot become a part of the executive decision. They have blurred the line, the differentiation that was made between legislative, judiciary, and executive functions. Similarly, of the CBI director, CJI has now encroached upon the executive functions. So these are the very, very important thing, which is why Arun Jaitley called it tyranny of the unelected. The concept of constitutional morality, please let me tell you, is a very dangerous concept. If you look at the entire jurisprudence, Indian jurisprudence from ancient history, from Mahabharata, even Ved and Puran, it is based on spirituality. In fact, the spirituality was discussed in the Constituent Assembly, and they said spirituality is infused in the Constitution. Morality varies from person to person. It's a Christian, concept which has been brought in, and therefore I certainly do not agree with the concept of a constitutional morality. Instead, it should be constitutional spirituality, where they have said, if a judge deliberately, does injustice or is, is corrupt, that judge needs to be destroyed. This is our scriptures say about it. And therefore, judges are not above the law or the Constitution. You cannot get into the domain of legislature or the executive functions. You cannot encroach upon that. And therefore, parliamentary autonomy and democracy cannot be diluted under any circumstances. Say, for example, tomorrow, the people of this country, and the people of this country are actually the star, not the North Star. Please remember that. We, the people of this country, they are the star of the Constitution. If tomorrow they think, instead of a prime minister system, let us have a presidential system of governance, because people think so. Can you stop that? Can you stop the people of this country having a new constitution? Because the old constitution maybe tomorrow may not be working. Maybe it is working today very fine. So you can't freeze the will of the people. People are supreme in a parliamentary democracy. And therefore, I think we have to be very, very careful on encroaching upon the legislative or executive domain, which the Supreme Court is doing. Okay. It is trying to govern the country through judicial pronouncements. No, it cannot be allowed.
Sanjay Hegde, do you believe, on the other hand, that the basic structure must be protected to ensure that democracy, which has thrived in our country and which allows discussions like this, which allows dissent, which allows freedom of speech, which allows so many freedoms, remains protected?
A constitution has to be something much more than the mere will of a temporary parliament. A parliament can be for 5 years. A constitution is designed to endure for the life of the republic. Now, if by an ordinary parliamentary procedure, you use the power of amendment to totally abrogate the basic features of the constitution. Tomorrow, supposing you were to say, let me amend the constitution, and instead of the prime minister, we shall have a monarch and we shall make it hereditary. You have changed. You have used your power of amendment. But if the doctrine of basic structure does not exist, there is no curb at all on any parliamentary majority of the day.
Mr. Hegde, how would you respond to those who say that the Constitution isn't static, it is almost a living entity? And if you look at it as a living entity which reflects people in our country, then it should also reflect changing circumstances. And those changing circumstances might, for example, reflect the views of those who are in power, who may want to change aspects or all aspects of the Constitution. How would you reply to that? I think that summarizes what Deshratan was saying. Yeah.
The reply is rather simple. While the Constitution is a living entity and can mold itself to the circumstances of the time, a Constitution has a structure. A Constitution has a skeleton. We set out to create a nation built on equality, liberty, and fraternity. Now, if you say that instead of that, we shall have a monarchy with one community alone being superior in all kinds, then you have a constitution. You may have used the amending power of the previous constitution, but you have created a new thing altogether. there is no flavor of the old constitution.
Okay.
Then what have you done? You have destroyed a constitution which you can't. That is why you say that is why the doctrine of basic structure, that certain things in the constitution are so sacrosanct that you will not change it. Not this parliament, not the next parliament or the one after that.
Deshrata Nigam, is it not true that several court judgments in the Keshavananda Bharti case were not completely concurring? In other words, that they may have favored the majority verdict, the 7 who voted in favor of basic structure, but they weren't entirely concurring with what, for example, Justice S.M. Sikri had argued. And therefore, as I understand it and in my own reading, it's the use of the words basic structure in all of the judgments which backed basic structure, just the mention of the words which they put them on the majoritarian
Vishnu,
side.
Can I be heard on this?
So,
can I be heard on this?
Question is to me. You'll have your chance.
I just want one line.
Sure, go ahead with one line and Deshratan after that.
The one line is this, that 9 of the judges at the end of all these conflicting judgments signed a common order saying that these are the conclusions. And that's how basic structure comes in.
Deshrata Nigam, go ahead.
Let me answer that. The crux of my argument is that the parliamentary democracy and autonomy cannot be diluted under any circumstances. And the star of this country are the people of this country. And let me tell you, India was existing before the constitution and will exist even after the constitution. Constitution is just about 1950 onwards. To say that it cannot be changed, we have seen constitution in the world being changed, simply dumped, and new constitutions have come and taking care of the existing circumstances, and that the international precedents are already there, which says that the constitution, you can have a new constitution because it reflects the will of the people. And will of the people is, we the people are the ones who are alive and kicking today, not the ones who are dead and gone, who gave us a constitution. We respect them, no doubt about it. They gave a wonderful constitution. It's still working. But we the people are the generations of today who are alive. To say that we are irrelevant and we cannot, do anything with the constitution is freezing India, freezing the will of the people despite changed circumstances. And those changed circumstances have to be taken into account. And let me tell you, the concepts that are being brought in, like constitutional morality, as I said, varies from person to person, country to country, society to society. Morality varies. And the entire Indian jurisprudence is based on spirituality. Anybody can read the subjects on it, which is clearly there. You go for the search of truth and disassociate yourself from the matter and then deliver the judgment. Is this happening in this country? No. So once you, and there is a book by the Supreme Court itself published, and if you read it, and Supreme Court judges seems to be ignoring that book, and once you read it, you will see the concept of spirituality is based on truth and seeking the truth, finding out the truth. Has our legal system been able to do that? No.
Okay.
Concepts like morality.
You keep speaking about constitutional spirituality. Mr. Hegde, would you like to respond to that?
That's a nebulous concept, not there in any judgment of the Supreme Court. Okay. So Mr. Nigam has brought it out for this debate. Otherwise, I don't find anything. And the book that he refers to, well, I was one of the editors of that book. Be that as it may. The thing is that as we hold the Constitution not only as a gift from the past, but in trust for the future. It cannot be that the will of the people can be transformed into Ein Reich, Ein Volk, Ein Führer, or one man, one leader. The leader of the moment, whether it be Mrs. Gandhi in the 60s and 70s, or whether it be the current leader, they can come, they can go, they can rule. But they take oath according to the Constitution. They have to rule according to the Constitution. They might require amendments in the Constitution for certain programs of theirs. But they cannot own the Constitution, totally abrogate it, and declare themselves emperors.
Okay, fair enough. I think that is certainly one large part of the concern, that we like our democracy the way it is. There are those who believe that perhaps every aspect of it can be questioned when the time is right through a parliamentary amendment. We leave it over there, out of time, on Left, Right and Centre. From all of us here, good night.